The first substantial legal document that will be part of your estate planning is the financial power of attorney. This is known legally in most locations as a general durable power of attorney. If you had a prior financial power of attorney, by us signing this version, we will then be revoking that prior version and installing this new one. This document is one of the most difficult ones to review during this process, not really because it's a difficult document, but mostly because it's very long and it's very dense. I'm going to proceed through with a much more in-depth review than what we provided during our review meeting, because I have the time to do so here. Your document may look slightly different than the version that I'm providing here, partly because over time our language changes within our documents as there are maybe new issues or better language that we can come up with to use. Yours also might look different because if you don't have a revocable living trust as part of your estate planning, then your power of attorney isn't going to include some of the language that you'll see here. But if you do have a trust, a lot of the language that you're going to see here will mirror what is in your particular power of attorney. Now, in reviewing this document, we will always provide a table of contents to start. We highly recommend that you start with the table of contents because there are key pieces that you want to review, such as the particular people that you're listing in each role. And what does it mean to be incapacitated? How does this document activate? A lot of the document, as you will note, is simply all of the powers that a person will have to be able to step into our shoes and manage our affairs if we are still alive, but we have lost that capacity to manage our own affairs, make our own decisions. The powers in Article 3 are derived from our state statutes. Any power of attorney serving by default is going to have the ability to manage all of these different components. This document is reflective of that in just a lot more detail. And at the end of the document, there's going to be some general provisions that apply across the entire estate plan that you may have. Again, some pieces may not apply to you here, such as if you don't have any children under the age of 18. But for purposes of our review here, we're going to include all of those so everybody can see what all of this means. Now, to proceed through the document directly, at the start is always going to be, who am I? And the fact that I am creating this power of attorney. In Article 1, we'll always be identifying who is the first person I am choosing to step into this role for me. And then, if that person cannot serve, who will any backups be? So at all times in your documents, just make sure that the people are correct. Names are spelled correctly, people are in the correct order. And if for any reason that needs to be changed, all you have to do is tell us, we will make those adjustments for you. 103 is simply providing that people may not always be able to serve. And so we need to have a process by which we can move through people to the extent that they won't be able to do that permanently. Article 2 is a very important provision to review. There is a point in time where we may no longer be able to make our own decisions or manage our own affairs. So Article 2 is going to provide a breakdown of how we determine incapacity. Most people, by an overwhelming margin, incapacity will be determined through doctors. So there's a process that's identified in here through physicians. It will tell you there are other circumstances when incapacity may be found. An example is that courts, probate judges are capable of determining this, as well as there are circumstances where people may be missing. There are circumstances where people may, unfortunately, be incarcerated. So to an extent, somebody becomes unable to serve. The person who is then stepping into this role will go through a process to determine any one of these. And then through that determination, they'll then be able to activate this document and make decisions. In Article 3, we're going to have all of the powers that are broken out for a person to be able to help us. Now, as I mentioned, this is derived from statutes. It is very standard and straightforward, even if it is very dense. So going through these, one thing to understand is that you are the person giving the power. So if there's something that you find in here that you are not comfortable with, or you simply just don't want to give that power for some particular reason, you can note that to us. We may still tell you that you want to provide the power and we'll give you a reason why. But if there's something that just absolutely is not something you're willing to give, then we can talk about that and we can remove that. It is your powers to give here. So you do not have to stay with exactly what is provided by these documents or by state laws. Section 3.01, this applies to people who utilize a revocable living trust for their estate planning. If you do not have a trust, you will not have this language in your power of attorney. But the purpose of this is, as you will recall, at all times we need to ensure that our assets are properly retitled, properly funded in order to be able to prevent probate. So in 301, this is providing if I cannot make my own decisions and run my own life, I'm giving you the power to take my assets and retitle them to then avoid probate if I had not already done that. Section 3.02, regardless of our circumstances, we need to make sure that our power of attorney has certain basic powers. So 302, as an example, the power to sell. Somebody needs to be able to liquidate assets of mine, especially if it means obtaining capital in order to take care of me and pay my bills. So 302 is a bit of an umbrella term, but it's allowing that power of attorney as needed to sell, to liquidate assets in order to be able to help us. Section 3.03, kind of the same idea fundamentally. My power of attorney also needs to be able to buy assets. Examples of that would be my power of attorney needs to be able to purchase insurance policies for me, or maybe to be able to sell my very big house and buy me a much smaller, more reasonable house. So the power to sell and the power to buy are always going to be implicit in what they can do. 304, the power to invest. Your powers of attorney, and if you also have a trustee, your trustee, they fall under a category that we call a fiduciary. And fiduciary is basically just a legal word that means I am managing the interests of somebody else. And so, as a fiduciary, there are certain powers that people receive, and there are certain limitations that are placed against them. One of those powers is we need to make sure that people can grow our money. So 304 is simply identifying that our agent has the ability to take our money, to invest our money, as well as to change those investments. As we get older, or maybe have a higher need for available cash, we need to ensure that our investments aren't risky. So our power of attorney will be able to change those pieces to make sure that it's in line with our objectives and our cash flow, and ensuring essentially that we will always have money available for us. 305, the power of attorney becomes you. So for all purposes, they can speak on your behalf, they can make agreements on your behalf, and they can sign documents on your behalf. So section 3.05 is simply itemizing that they have the power to contract. Section 3.06, when I own real estate, what we call in the legal world real property. This includes actual properties, homes. It can include land, vacant land, farmland, agricultural, etc. It can include timeshare interests, and it can include commercial real estate. I need to ensure that this can be managed. So to whatever extent, if somebody is stepping into my shoes, they're going to be able to manage all aspects of this real estate, this real property. And to whatever extent, they can make changes to it, such as if there is a tenant, they can evict the tenant if needed. Or if it's time that we need to sell the property in order for me to be able to have cash flow, they can sell that property. Section 3.07, tangible personal property, is a legal term that simply refers to our stuff. So when it comes time that people need to step into our shoes, we need to ensure somebody can manage our sofa and to make decisions about our jewelry and protect our property or liquidate our property if we need for any purposes, such as downsizing me to a new residence. So 3.07 is simply making sure that our power of attorney can make these decisions, provided They are those fiduciaries that I mentioned. And so decisions about all of this at all times are going to have to be made reasonably and in good faith, and that people can't just go and make decisions for the sake of it. It needs to have a purpose to further our benefit. Section 3.08, digital assets is an issue that has come up quite a bit in the last couple decades. We need to ensure that our power of attorney can access and secure and maybe manage ongoing the digital assets we have. For some of us, that's something as basic as like an email account, a Facebook account, an Instagram account. For other people, they might have websites, they might have followings on YouTube, they might have income that actually gets derived off of their digital assets. So this section is just ensuring that our power of attorney has the ability to access and control any number of digital assets we may have. Section 3.09 isn't likely to apply to most clients, but it can apply at any time in the future. So that's why we want to keep this language in here. Section 3.09 is providing power of attorney. You have the ability as needed to access and manage and protect and control and even dispose of any oil interests, gas interests, mineral interests otherwise that I may have. Section 310, if I happen to own a business at the time I'm incapacitated or even have a minority share of a business, I need my power of attorney to be able to step into my shoes for that. So section 3.10 is allowing for that. Section 3.11, securities is a broad term that encompasses a number of different types of investments and financial products. So there are different rules that apply to different types of products. We need to ensure that our power of attorney as needed can manage all of them. So section 3.11 is simply giving them that power. Section 3.12, to whatever extent somebody has an obligation to me, whether someone owes me money, or if I'm in the middle of a lawsuit when I happen to become incapacitated, I need somebody who can then step in and continue those efforts to collect on those debts or continue that litigation or whatever it may be. So 3.12 is giving them the power to do that. Section 3.13, at any time, our power of attorney may need to interact with the government in terms of benefits that we may either be receiving, such as if I'm receiving Social Security or Medicare or anything like that, or if I need to start receiving government benefits. My power of attorney can actually apply for Social Security for me. So 3.13, it's a bit detailed, but it's providing all of the abilities that somebody is going to have to be able to step in and represent us on behalf of any governmental benefit programs. Section 3.14, to whatever extent I have retirement accounts, to whatever extent I have particular benefits through my employer, whether I'm still with them or they're just lingering after my employment. Section 3.14 is going to provide my agent with the power to manage all of those benefits for me. Section 3.15, my power of attorney as needed is going to be able to manage all of my financial accounts. So savings, checking accounts, certificates of deposit, etc. We want to make sure that they have a provision that they can walk into my bank, take over, make sure that all of it is being managed and protected. Section 3.16, my power of attorney is going to be able to manage any lines of credit that I may have. This could be a credit card as an example, or maybe an actual line of credit that I have with an institution. I need to make sure that they are not only monitoring my cards for purchases that are happening for potential identity theft, but also that they can cancel those cards, that they can close those accounts if I may need. To the extent that you have a safe deposit box, Section 3.17 is providing our power of attorney with the ability to manage it, the ability to access that account, the ability to make sure that it is taken care of, that any particular property inside of it is secured or removed. Section 3.18, my power of attorney as needed has the power, if it comes up, to file lawsuits or to defend lawsuits that may have been filed against or involving me. They step into our shoes as if they are us in order to proceed through those cases, though the liability for anything in terms of finances will, of course, stay with me. Section 3.19, this is one area that we probably receive the most questions. When a power of attorney steps into our shoes, by default, they are given certain powers to, number one, obtain any types of loans or lines of credit on our behalf, or two, to allow people to borrow money from us. One of the questions that commonly comes up is, well, why would I want somebody to be able to do that for me? Well, on the loan side, consider situations where perhaps you need to purchase expensive medical equipment. Most people, they either don't have that money in hand to be able to make that purchase, or they wouldn't necessarily just want to take that large of a piece of money in order to be able to make it. So instead, it might be more favorable if we make that purchase on credit. In terms of the ability to loan money, what we might find is where we have parents that might loan money to their children on a regular basis, and their children might pay it back. So if that's something that we've commonly done, our power of attorney can continue that for us. In terms of this particular process, and this particular section, I should say, sometimes we leave it as is. Some clients will say, I don't necessarily want people to take out new debt for me, so we might restructure this to provide that they can only manage our existing debt. And then other people as well may just say, I don't ever want somebody to have the ability to let people borrow money from me. That's okay. If you have particular notes on this section, let us know. We can make those adjustments. 3.20, when we are alive, other people may take some effort to name us in certain roles, such as my own parents have named me as trustee of their trust. I am in their power of attorney, etc. Well, I might be in a position where I can't perform those services, but I don't have the capacity to be able to step down from them. Well, my power of attorney can do that for me. So if I'm not able to serve in a particular role, on my behalf, my power of attorney can renounce that role if I haven't received it yet, or they can resign from that role if I was already serving in it. 3.21, the term disclaimer, it's a legal term that essentially means I am not going to accept this from you. It commonly applies in the realm of inheritance, where perhaps my parents would leave me money, and I might say, I don't want to receive that. I'm going to let it drop down to grandchildren. So I could issue something called a disclaimer that says, I'm not going to take the inheritance from you. Section 3.21 is making sure that our power of attorney has the ability to do that on our behalf if needed. I will tell you the most common example why this is going to be used. If I am in a nursing home and I am receiving Medicaid, I have limits on how much money I can receive. So if somebody leaves me inheritance, I am very likely to lose those benefits, and I'm likely to lose my spot in that nursing home. But if somebody were to disclaim that inheritance for me and allow it to pass through me, that'll allow me to keep my benefits. So that's why we would typically use this. Section 3.22, our power of attorney at all times simply needs the ability to manage our insurance. So they can take out insurance policies, manage existing insurance policies, and even cancel policies if needed. Section 3.23, our power of attorney at all times also needs the ability to manage our taxes. Not only to be able to file taxes for us, but to make sure those tax debts are paid, as well as to contest any taxes or negotiate any resolutions on taxes that may come up with the state or with the federal government. 3.24, finally, a question that we get about this often is, if I'm married and my spouse is listed in my document, why would they need the power to deal with my spouse? And the issue very simply is because your spouse may not always be able to take care of you. There could be a situation where both of us are in a car accident. I have my power of attorney stepping in and helping me. My spouse has their power of attorney. It could be the same person, technically, or it could be two different people. So we need to make sure at all times that our marital partners, that we have the ability to make decisions with them and work with them, even if it's not them who the decisions are being made with. Article 4, there are certain express limitations on what a power of attorney cannot do for us. These are a little bit attenuated. I've actually never once in my entire career ever seen these happen, but they are dictated largely by statute, and so we do like to include these. An example is if somebody is acting as my power of attorney, the income that's coming to me that they're managing, we need to make sure that that income doesn't accidentally get attributed to them and that they suddenly have to start reporting my income and paying taxes on my income. We also need to make sure that they don't violate the conflicts of interest that come up as being a fiduciary. And so we want to make sure that we avoid any potential misclassifications of things as gifts to my power of attorney. You're welcome to read this. If you have a question, you're more than happy to answer. But generally speaking, I can tell you I have never once had one of these issues come up, but we do like to keep this in here just to be crystal clear. In Article 5, there's just going to be several miscellaneous provisions. So 501, when it comes to the person that's serving for us, the power of attorney, they are going to be able to access any information that's needed. This document as a whole acts as a legal release for third parties to provide them that information, such as my accountant releasing my tax return and my tax information to my power of attorney. They need full access when they're serving to be able to do the job. 502, the purpose of doing estate planning is that we avoid having to go through probate. A power of attorney avoids a certain probate type that's called conservatorship. However, for any number of reasons, somebody might try to file a conservatorship. This section 502 is essentially clearing this up and saying, regardless, I am the power of attorney, and if anybody ever tried to file for conservatorship, I am also going to be the conservator for this person. 503, if you happen to have minor children under the age of 18, we're going to nominate guardians. They're going to be both in our power of attorney because this activates while we are alive. And if we can't provide that care to our kids while we're here, we need somebody with the legal ability to step in and provide that care for us. It could be permanently, but it also very likely is just temporary. I may only need somebody to take the kids for 2 months while I'm recovering. Guardian nominations will also be in your will, which we'll see in a moment in another video. 504, when someone steps into our shoes, they may put out money from their own pocket for any purpose related to us. If they happen to do that, that is perfectly fine. They are entitled to be reimbursed for those expenses later once they have access to my money. They just need to keep good records about those things. 505, any document that we create at any time for the rest of our lives, we can change it as much as we want, or we can just completely get rid of it. I can change my estate plan as long as I'm still here and I have that capacity to make those decisions to understand the changes that I am making. 506, my power of attorney, the person I've selected to step into this role, they're not required to do it. So if for some reason a person maybe becomes sick or has an accident, or honestly just maybe has too much going on in their lives, they don't have to continue serving. Whether it's before it's come to them or after they've been serving for a period of time, it doesn't matter. They can resign and it will drop to the next person listed. That's why backups are always very important. 507, everything that we do here is going to be governed under the laws of the state of Colorado because that is how we're creating the estate plan. However, keep in mind, your plan goes with you anywhere that you may go. So if you may start living in Missouri or you are vacationing in Montana and there's an accident, your documents go with you. Nothing is stuck effectively in Colorado. 508, with respect to third parties, such as the bank that your power of attorney is working with, As long as people are relying in good faith on the power of attorney, there's not going to be any problems. The problems that I have experienced in doing probate work for many years are I might have a bank that says, we're not going to honor the power of attorney. We're not going to let them make decisions for you. And that is what it is. I, many times over my career, had to sue banks to be able to force somebody to actually be able to do the job that they were listed to do. And in situations like that, that bank gets sued and they usually get sanctioned, and there's usually quite a bit of an issue on the back end for them because they failed to honor this. 509, as a reminder from our very first time talking, when we help clients with estate planning, we provide two versions of their documents, the original signed versions and then a digital copy. The copy is shared through that platform we use called MyCase. So this is just a reminder here. Your documents, if somebody has a copy of this in their hand, a copy will be just as effective as the original that you will keep in your possession. 510, again, everything right now is being governed under Colorado law because that is where you are signing the documents. And then 5.11 is a legal term called severability. And the basic definition of that is if a judge were to ever look at a legal document and say that provision isn't legal anymore or isn't legal ever, then that particular provision can be cut out of the document and the rest of it will be used as a whole. This isn't something you're ever going to see in estate planning documents, but a common example would be if two people came together to write up a contract and they wrote in a bunch of different terms, and a judge ended up looking at that and said, no, that particular term, that doesn't work. And then 5.12 is simply a definition. You'll see these terms shall and may throughout the document. This is just defining what each of those mean because they are two different things. At the end of this, simply, is a signature. So this is your most dense legal document. Even when you have a trust, this is usually honestly one of the hardest ones to read. So take your time with it. If there are any questions that come up that weren't answered in this video, you're more than welcome to ask them. And then otherwise, as mentioned previously, as you may have any notes, changes, etc. throughout the document, you're welcome to make that in your file and return that to us. Please go ahead and continue on to the next videos for any additional documents you want to further review for.